So in Davidson versus Commonwealth, we're looking at another example of an issue of whether something is an appropriate lay opinion bit of testimony. And so in Davidson, the detectives, or one of the detectives, wants to testify that three of the robberies in question were, in his mind, related. And so the question then becomes whether that's the appropriate subject or an appropriate subject of lay opinion testimony. As we've been talking about before, and we'll talk about more subsequent to this, lay opinion testimony is essentially shorthand. So we would say, the boat is large, the car is small, the weather is warm, the weather is pleasant, the man ran quickly by me, et cetera, et cetera. Things that we all use to describe that amount to an opinion that obviously comes from your own personal bias. What's fast to me might be slow to you, and vice versa. Someone is smart, someone is dull. Those kinds of things would be very different depending on who you are as an observer, but those are the ways that we typically speak. And that's often why when we talk about biases and perception and the vantage point from which you approach a question, that's why very often we want to have live in court testimony so we can inquire about things. What is fast to you? But the question is, can a person testify in the form of an opinion? And the answer is absolutely, but when and under what circumstances? So in Davidson, what we're looking at is an officer who says these robberies, in his view, are connected. Obviously, the defendant doesn't want that testimony because if the jury finds, overwhelming evidence or sufficient evidence for one of the robberies, and part of the evidence is that the detective says they're related, well, then the jury can then simply offer the evidence of the one robbery as some evidence that adds to the question of whether the defendant committed the other robberies. So this is problematic for the defendant, but is it consistent with the rules on lay evidence or lay opinion evidence? And the court says it is problematic, because what are we actually looking to do with this sort of stuff? We're looking at the shorthand. We're looking at a person's individual perception, and that person's perception adding something to the jury's analysis. So here, it's not like the detective actually saw the robbery occur, and even if he had, the fact that he sees a connection between these two things doesn't bring any new information to the jury. So like if the witness was there and saw a car zip by him at 100 miles an hour, and he said that car was really moving fast, his perception that a car went by him going fast would be information that he brought to the table when he came to talk to the jury, and there would really be no other way to describe a car going by him very quickly other than to say that in the form of an opinion, unless of course he has a radar gun on it, and then he's no longer a lay witness. He's an expert offering sophisticated technology. So the court says in this case, it's not like a connection that the officer sees brings anything to the jury's considerations, and it's not like the officer is talking about something that he's actually observing. And so in Davidson, this is an example of something that does not qualify as a lay opinion, because it's not based on a shorthand description that is in effect a type of opinion that is something that that would be helpful to the jury. So to come in as a lay opinion about a topic, it has to be a description of what the witness saw, and his or her description has to be helpful to the jury, even though it's in the form of an opinion. If this witness thinks it's fast, if this witness thinks it's heavy, if this witness thinks the person's smart, that could all be helpful to the jury. We'll want to have the ability to cross-examine the witness on what it takes for this witness to regard something as heavy, smart, slow, fast, etc. but that could be helpful. It's not helpful when it doesn't add anything to the jury's analysis of a case if someone who just looks at it from the outside sees a connection between these two robberies. The jury might look at it and see that, but without any kind of training or expertise, which is what a lay opinion is, a non-expert who looks at, three robberies and says, these all look connected to me, that person is not doing anything above and beyond what a jury is fully capable of and expected to do.